Safoy, who was elected to the 14th Judicial District Court bench in 2001 and re-elected without opposition for a full 6 terms twice. He's an U.S. Navy veteran and served as Vice President of the Third Circuit Judges Association. Judge Safoy is married to his wife Pat, and they have 5 children, 12 grandchildren, and another grandchild on the way. Ladies and gentlemen, the Honorable Judge Safoy.
Good morning.
Good morning.
Our topic is religion's freedom and how to protect it. I want to begin by quoting from the preamble of our United States Constitution, which says, "We the people of the United States, in order to form a more perfect union and establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." The Constitution goes on to primarily establish the branches of our federal government, their functions, and put certain checks and balances in place. The Constitution was adopted in 1787 and was ratified and went into effect in 1789. Several delegates to the Constitution Convention refused to sign it because it did not include a Bill of Rights. Bill of Rights were typically parts of the Constitution of several states of the day and of today, and they were placed there to ensure that certain rights were recognized by the government. There was also a concern that the federal government would become too powerful. The lack of a Bill of Rights was one of the main arguments. Am I speaking too close? Okay. The lack of a Bill of Rights was one of the main arguments that anti-federalists used to convince the public to try to vote against the Constitution. But the need for change was too evident, and so that was rejected. But several states sent messages to the Congress saying that these are some things that we think ought to be listed. And so, in the first meeting of the Congress, James Madison, who was instrumental in the creation of the Constitution, set forth certain bills of rights. 12 of those were submitted to the states after they had been approved by Congress, and 10 of those were adopted by the states, and we know those as the first 10 amendments, today called the Bill of Rights. In a case called Gobitis, which I'll discuss shortly, Justice Frankfurter said centuries of strife over the erection of particular dogmas as exclusive or all-comprehending faiths led to the inclusion of a guarantee for religious freedom in the Bill of Rights. And in a Barnett case, which I'm also going to discuss, Justice Jackson said the purpose of the Bill of Rights was to withdraw certain subjects from the unexpected changes of political controversy, to place them above the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, freedom of worship, and other fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. According to the Constitution, the United States Supreme Court has the final say on whether legislation is constitutional or not. The Supreme Court is made up of 9 justices who are appointed by the President for life and subject to the approval of the Senate. Every recent president, it seems, has tried to appoint or has appointed someone they believe will decide cases in conformity with the beliefs of the president. The Supreme Court has dealt with the freedom of religious clause contained in the First Amendment in many cases over the years, and sometimes their decisions come out differently based on essentially the same set of facts. I want to talk about 2 cases. The first one is Minersville School District versus Gobitis, which was decided in 1940. In that case, 2 Jehovah's Witnesses school children were suspended from school for refusing to salute the flag. In a nearly unanimous decision, the court ruled that the school district's interest in creating national unity was sufficient to allow them to require students to salute the flag. 3 years later, in West Virginia Board of Education versus Barnett. The West Virginia Board of Education used the language from the Gobinas decision to establish a rule that students must salute the flag. In the 6-3 decision, the court ruled that the school district violated the students' rights by forcing them to salute the American flag. This decision directly reversed the Gobinas decision. Justice Frankfurter, who dissented along with 2 other judges, complained that the precise issue had been presented to the Supreme Court on 5 prior occasions. In 4 occasions, it was unanimous that the state could impose the right to require people to say the Pledge of Allegiance. In the 5th case, the Gobinas case, it was an 8-1 decision. And yet, 3 years later, they're changing it. Why? Barnett was decided with 2 new judges who were appointed by the President Roosevelt to replace 2 judges who had retired. And there was a new chief judge, also appointed by President Roosevelt, who had been a dissenter in the first case. My point is that the President decides who to appoint. It's generally believed he will pick someone who will believe as he does. Congress and state legislatures pass legislation which may infringe upon your religious freedom. Therefore, you should know what's important to you, and you should then determine if the candidate that you're voting for, whether it's President, Congress, state legislators, governor, has the same beliefs as you. And we need to be ever vigilant, as Judge Ritchie talked about, to pay attention. There are lots of things that affect religious liberty. You should elect senators and representatives who will not enact legislation that impinges upon religious freedom. And you can do things like you're doing here today to let them know that you think that religious freedoms are important to you. That's what our forefathers felt when they adopted the Bill of Rights. And I thank you for that.